My name is Khiara Bridges. I'm a professor of law at UC Berkeley School of Law.
Well, thank you for joining me, and we'll be talking about your 2022 article, Forward Race in the Roberts Court, which was published in Harvard Law Review, and their Supreme Court 2021 term issue. So I think I want to begin by asking you, how long have you been watching the court? How long have you been thinking about race in the court? And how long did it take you to put this together?
Right. So I've been watching the court at least since I was in law school, and I started law school in 99, graduating in 2002. So that's over 2 decades of watching the court. I became interested in race in the court probably around about the time that I started watching the court. I wanted to go to law school to study. I thought I wanted to study sort of health law, but if you ask health law scholars, health law tends to be a very kind of narrow and very sort of technical and technocratic sort of area of study. And so the discipline of health law um, didn't excite me as much as thinking about health and law. So I became interested in looking at how the court thinks about health and law and how race impacts or how just race is implicated in its thinking around race around health and law. So yeah, so all of those things kind of drove me to law school and to kind of my area of expertise. And the final question that you asked was, how long did it take me to put together the article? And as you know, because you've read it, it's a substantial piece of scholarship. It's what 150 pages or so, and so usually something of that kind of just depth and scope takes a very long time to put together. But the thing about the forward to the Harvard Law Review's Supreme Court, term, issue is that you have to do it very quickly. And so I got invited to write the forward in October, and I had to give in a final draft in June. So that so that's not a lot. That's not a lot of time to put together the article. That being said, a lot of the ideas in the article were percolating in my brain for years, and so the invitation to write the article just gave me an opportunity to formulate them, articulate them, and then to put them out there into the universe.
Yeah, thank you. It's an impressive piece, and there's a lot of footnotes, which I expect from any law review article, but it definitely has quite the evidentiary support. So the first question I was going to ask is, if you had to define race or kind of sum up how the Roberts Court deals with race in like an elevator pitch, what would that like 3 or 4 sentence kind of summary be?
Yeah. So in the article, I argue that the Roberts Court sort of treats racism as kind of how we imagine racism, the forms that it took in like the pre-civil rights era, like in the bad old days. So think, the KKK, think, white supremacists kind of burning crosses on people's lawns, think of, prosecutors trying to pin murders on innocent, Black people, kind of like these obvious and flagrant and overt demonstrations of racism. So that's how the Roberts Court understands racism. And so when the Roberts Court confronts sort of allegations in which a person of color is saying that they have experienced racism, the Roberts Court is looking for that. They're looking for the Klan. They're looking for, the anti-Semite. They're looking for, overt forms of racism. George Wallace standing in front of a schoolhouse door saying segregation now, segregation forever. That's what the Roberts Court is looking for.
It's on the opening pages of your article too. I want to read this because it struck me so profoundly. Thus, the judiciary approaches laws that are intended to dismantle the nation's racial hierarchy with the same degree of constitutional skepticism as it does laws that are designed to reproduce and protect it.
Right.
What do you mean?
What do I mean by that? So the court is in the business, the Roberts Court particularly is in the business of saying, okay, I'm looking for these, I call it old school racism. And then let's also be clear that my critique is that in the post-civil rights era, racism, certainly those demonstrations of overt racism exist. But the sort of techniques by which the racial hierarchy, today's racial hierarchy is reproduced, tend to be much more subtle, right? They tend to be much less overt, much harder to suss out, and point to and say, there it is. That being said, in the post-civil rights era, we have, as a country, decided at some point that we need to kind of dismantle, racial inequality. And we've done it through various mechanisms, many of which are conscious of race. So affirmative action is kind of the most salient example. We've said that, in these elite institutions of higher learning, people of color, particularly Black, Latina, and Native people, are just not there. And so in order to get them into these institutions, we're going to allow admission offices to be conscious of race. We are going to allow them to think about race when determining whether a student is admitted or not. The court looks at those efforts to dismantle the nation's racial hierarchy, to sort of undo racial inequality, with the same degree of skepticism as they look at efforts that say no Blacks allowed, no Jews allowed, no Irish need apply, right? So when a law has race on its face, the court says, oh my God, that's unconstitutional. But of course, laws have race on their face for many different reasons. Sometimes it is exclusionary. Sometimes it is designed to sort of reproduce racial hierarchy. And other times laws have race on their face in order to undo that racial hierarchy. But the court pretends not to know the difference between those two things. And so the court treats those same types of laws the same, being inclined to strike them both down.
Yeah, and we'll get into how that works in a second, on the ground in one of these cases. But there's also, you make the very striking argument, and you convinced me of it without a problem, which is that that's how they approach people of color, looking to pre-civil rights examples. But for white people, they use a whole different scheme. And could you kind of give us what that scheme is and how it's kind of a novel approach?
Right. Yeah. So with regard to people of color, as we've already sort of established, the court says, hey, can you convince us that this racism that you say exists out there kind of reminds us of, the Klan or, white supremacists or, can you convince us that there is a similarity there? However, when it comes to white claimants, when white claimants say, hey, court, I've experienced racial discrimination, can you strike down this law? The court doesn't require white claimants to demonstrate that this alleged discrimination reminds us of what happened in the pre-civil rights era. Instead, the court says, well, white claimant, do you feel like you've been discriminated against? Do you feel like this law is unfair? Has this law disappointed you? Has this law, thwarted your expectations? And if so, then we will say that that is racial discrimination, and we will strike it down. So we have sort of two different standards when it comes to what claimants have to prove in order to make a claim that the court finds to be convincing that there is racial discrimination. With people of color, the claimants have a very, very high bar. And when it comes to white claimants, again, white claimants just have to say, this law is unfair. I think it's unfair. I feel discriminated against. And the court is much more likely to strike it down as unconstitutional or in violation of anti-discrimination law.
Yeah, and we hopefully can look at something that kind of illustrates that. But I was thinking too that this is one of those instances where the court is so frustrating in the Roberts era, because there is this historical precedent looking like, what does it say in the Constitution? What was the current time, the originalist argument
Right.
versus non-originalist argument, the precedent argument, that kind of thing. And is that what you're talking about with this, where everyone's become a legal historian all of a sudden? Or is what's going on with the court and its relationship to precedent and also history? Because it seems like they deploy both willy-nilly.
Yeah, absolutely. Oh, absolutely. I actually just came from a conference in which I sat on a panel in which I talked about this, right? This selective originalism, right? This pragmatic originalism, originalism being deployed in order to accomplish certain ends. And then when it's not useful to accomplish those ends, then you never sort of hear about originalism. But I'm actually making a different argument in this article. I'm not talking about originalism necessarily. So the court certainly invokes originalism in Dobbs, versus Jackson Women's Health in order to say that Roe versus Wade was incorrectly decided. And I certainly talk about that in the article. But when I say that the court is looking for kind of relics of racism, looking for like these overt demonstrations of classic racism. I'm not saying that the court is doing that because they're so interested in history. Instead, I'm saying that the court is doing that because I say it's a strategy in the article, but the court is sort of looking for these sort of relics of racism in order to sort of maintain its legitimacy. Because if the court were not to strike down some of these sort of overt demonstrations of racism, it would be harder for the court to say it's a legitimate institution, like with a straight face. So it's trying to maintain legitimacy, but it's also trying to do the bare minimum when it comes to undoing the nation's racial hierarchy and sort of producing racial justice. I also just want to add that on this sort of selective originalism point, if the court really felt that originalism was like a command, like it had to interpret the Constitution by looking to what the founders did or looking to what the framers intended, or by looking at what the public during the time of the ratification of the Constitution was thinking, then the court's affirmative action jurisprudence would come out very differently. In Students for Fair Admission versus Harvard, in which the court struck down Harvard's and UNC's affirmative action program, there is no mention of what the nation was thinking in 1868 when it ratified the 14th Amendment and included that equal protection clause, equal protection language in there. Because if the court looked at what the people were thinking in 1868, we were just coming off of the Civil War. There were a whole bunch of race-conscious laws designed to make formerly enslaved Black people sort of full citizens. And so an effort that was race-conscious to produce racial equality certainly was permissible. That was kind of like the whole point of the 14th Amendment. So race-conscious laws, when it comes to admissions, would be permissible if we're thinking about what the people in 1868 were doing. In Students for Fair Admission versus Harvard, there's no mention of 1868. Instead, the court makes policy arguments about why affirmative action is unconstitutional or is bad for the country and so on and so forth. So again, this is an example of that sort of selective original, that pragmatic, opportunistic, looking to history in order to sort of accomplish certain ends.
Yeah, that's a good, thank you for clarifying that. I do want to look at how you deploy race and class together in, or at least the way I read the way you deploy race and class in the Dobbs and in the gun right, the Bruen, I think it is. Those two cases deploy racial history in an interesting way to support the overturning of Roe and the supporting of, or the striking down of New York gun laws as a defense of Black people.
Yes.
At first, I was very confused by it because it doesn't seem to make sense. But then when you put it in the context of the bigger picture, it totally did. So just kind of briefly walk us through what those cases, well, we know what they did, but like how you develop your argument about them.
Right. Yeah. So, I will admit and avow that I am a reproductive justice scholar. So that means that I look at reproduction. I'm interested in how reproduction is regulated in ways that support or dismantle racial inequality. And so, as a reproductive justice scholar, I look at race. I look at abortion laws, and I would say that most reproductive justice scholars have concluded that abortion regulations are incredibly harmful for a number of reasons. And I actually don't think that we have time to get into those reasons today. But for like a number of reasons, abortion bans harm people of color, in part because people of color have more unintended pregnancies than their, white counterparts. Because they disproportionately bear the burdens of poverty. And so they disproportionately feel that they can't carry, these pregnancies to term and adequately and competently and lovingly raise these children. Abortion bans criminalize people. And so when we think about our criminal legal system, who is swept up into that criminal legal system disproportionately? That's people of color, right? So and also I would be so remiss if I failed to mention that Black people die from pregnancy-related causes at higher rates than their non-Black counterparts. Black women experience maternal deaths at 3 to 4 times the rate as white women. So, right, abortion bans force people to carry pregnancies to term. And in the United States, it is dangerous, right? It's more dangerous for a Black person to carry a pregnancy to term because of these racial disparities in maternal mortality, right? So that's how sort of reproductive justice scholars think about race and abortion. We think that abortion rights are necessary in this sort of vast, this expansive program of racial justice. The court in Dobbs doesn't think of it that way, right? The court in Dobbs it's listening to this sort of conservative legal movement that says that actually abortion rights are techniques by which a genocide is being committed, right? It looks at those disproportionate rates of abortion amongst Black people, and they say, I told you guys, I see, look, Black people are being targeted for abortion care. Right? There are bad actors out there who are sort of coercing or duping Black people into terminating their pregnancies, and it's part of this sort of grand scheme to eliminate the Black race. So abortion rights are like techniques by which this genocide is being inflicted on Black people. And so the court listens to these conservative legal arguments and it says, well, that makes sense. that makes sense to us, right? Because again, genocides are sort of classic techniques by which, in the bad old days of the pre-civil rights era, sort of racial hierarchy was produced and reproduced. And so the court says, that makes sense to me. I do believe that abortion is dangerous to Black people. And so we're going to protect Black people from abortion by allowing states to criminalize abortion care. And so that was part of, the Dobbs reversal of Roe versus Wade was supported by many, different arguments, but that certainly appeared in the opinion, this sense that Black people need to be protected from abortion, and they're going to do it by reversing Roe versus Wade. And then when you look at Bruen and you look at the gun rights case, a lot of racial sort of justice, advocates and activists believe that, the proliferation of guns and the failure to regulate gun ownership or usage even is harmful. Because, so frequently, disproportionately, Black men particularly are victims of gun violence. And so the sense has been, from a racial justice perspective, we kind of need to regulate, who has these guns, because when we don't regulate who has guns, they just proliferate, and it just too often Black men, young Black men particularly, are on the deadly side of a firearm. And so again, there's been this positive relationship between racial justice and gun regulations. But then the court says that doesn't jive, that doesn't make perfect sense, because it looks to opportunistically history in which during the Reconstruction era, after enslaved people were freed, there were certainly bad actors, white supremacists, who said, we kind of need to reinstitute slavery in another form. And then we will be thwarted in our desires to reinstitute slavery in another form, or at least to keep Black people as a subordinate population. We're going to be thwarted if those folks have guns, because they'll be able to defend themselves. So let's disarm Black people as kind of like it's a part of a program of maintaining racial hierarchy. And so again, we can look through history and we can see a number of different instances in which intentionally disarming, formerly enslaved Black people in order to render them easily killed. And the court says that's what gun regulations look like. When New York says we're not necessarily going to allow you to carry a firearm, the court says that kind of reminds us of these white supremacists back in the Reconstruction era who denied Black people the ability to carry weapons in order to defend themselves. And Bruen is really remarkable because Alito, makes these arguments about like kind of, and, picking up on Thomas, because Thomas started it. But he picks up on these arguments in which he says, actually, Thomas wrote the majority opinion in Bruen. So my apologies for that. But Thomas has long argued about Black people need guns in order to protect themselves. Like gun ownership is kind of like a necessary element in racial freedom, right? And so the Bruen strikes down these sensible, in my view, gun regulations, and it's part of this desire to protect Black people from a disarmament that began in the Reconstruction era.
So to a layperson, it seems like both those arguments are valid. So, it seems like you want people to be able to defend themselves, and especially Black people who live in bad neighborhoods and are higher victims of crime and murder and all that kind of stuff. So what is this actually doing, and why isn't it doing what it seems to be doing on its face? So like, okay, abortion was started by a eugenicist. So why isn't it a genocide? And what is you know what I'm asking? Because it's confusing, because your argument is incredibly well nuanced and I think really important. So could you tell us more about why those arguments are not what they seem to be?
Yeah, I mean, so I think that well, there's a lot of different ways if you're interested in distinguishing abortion rights from like a eugenic plot or a genocidal plot, right? And one of the primary, and in my scholarship and my thinking, one of the primary sort of characteristics that distinguish the availability of abortion care from eugenics or from genocide is autonomy. And so, like, one thing about genocide and one thing about eugenics is that the people whose reproduction was regulated and the people who were killed certainly did not consent to their, either coerced sterilizations or forced abortions or their murder, right? When we think about abortion rights today, I'm unaware of like a massive program of people being coerced into having abortions. When Black people disproportionately have abortions, and then I talk about this in the article and I talk about this in my scholarship, it is this exercise of agency. It is and now, mind you, I think it's so important for people watching this to understand. Like, I certainly believe that Black people's disproportionate rates of abortion evidence marginalization, but I don't think it's because somebody's forcing Black people to get abortion. Instead, I think this disproportionate marginalization, this disproportionate vulnerability is a function of structural racism. It's because of the lack of healthcare. It's because of the lack of sex education in schools. It's because of the inability to control the conditions under which you have sex. It's because of, right, all of these sort of systemic issues that make it so that Black people suffer from higher rates of unintended pregnancies and therefore need abortions. So yes, racism is implicated in in Black people's higher abortion rates, but not because people are being forced into having abortions, but rather because they are sort of vulnerable and therefore abortion becomes necessary in order to help them manage their vulnerability. And we could do a similar analysis in the context of guns. Um, the Roberts Court believes that, I mean, it really implies that New York and California and these other states that have kind of more restrictive gun regulations, it sort of implies that those restrictive gun laws are kind of just like it's antecedents were these laws that disarmed Black people during the Reconstruction era. Whereas if you actually look at what New York and California and other states with more restrictive gun laws are trying to do, they're trying to stop gun violence. um, Not saying that they're trying to save Black people's lives, but they're trying to stop, gun violence. Um, I just came back from Europe, and it's so refreshing, or I wouldn't say refreshing, but it kind of brings into greater relief just how bizarre the US is when it comes to just the easy availability of guns and the fact that sort of gun ownership is a banality. And so what California and New York is trying to do is connecting the easy availability of guns with just the ridiculously high rates of gun deaths that we have, and they're trying to sort of diminish, those numbers a little bit. Um, I see no evidence of this desire to disarm Black people to make them unable to defend themselves. I think that we can do a whole lot as a society to sort of protect and conserve Black lives. But trying to protect and conserve Black lives through ensuring that they have access to a gun is a very odd sort of effort. Surely there are other things that we can do that are life affirming that don't involve um, making sure that people have the ability to take somebody else's life.
Yeah, and I think in listening to you explain it too, I think what I hear you saying is that both of these arguments, while seeming to protect Black people and uphold some sort of anti-racism, are actually just missing the point of anti-racist systemic systems. So there's a white supremacist system in place, and these justices are intentionally moving away from it and saying,
Yeah,
hey, this is real racism. What you're talking about isn't racism. Is that a
that is a fair characterization of my argument. I think that what the Roberts Court does in Dobbs and what it does in Bruen is a move that allows the Roberts Courts to say that we are the real anti-racists out here. Like we are actually interested in protecting Black lives, and Democrats and Sotomayor and Kagan and all of those Ketanji Brown Jackson. I don't know what they're trying to do, but like we are interested in actually producing racial justice. Whereas if you talk to if you look at these issues from a different perspective, which of course the court has those perspectives in front of it, not simply because of the dissenting justices, but also because of briefs that are submitted to the court. For example, I submitted a brief to the court in Dobbs in which I tried to tell everybody, I tried to tell all 9 of them that if you really want to lower Black rates of abortion, you wouldn't do it through banning abortion. Instead, you would do it through making sure they had access to contraception and lifting them out of poverty and making sure that they can control the conditions under which they have sex and making sure they have sex ed in their public schools. And right, so there are so many things that we can do in order to reduce Black rates of reproduction, but the most coercive, autonomy denying, agency denying method is to just say, abortion is unavailable in your state, and good luck getting to California because it's still legal over there. So so yeah, if we really were interested in preventing kind of like Black death, there are other ways of doing it besides doing what the courts does in Dobbs and Bruen.
Right, and especially when you combine it with the medical cases that are going to be coming up against the court in the future terms here, it's going to be incredibly fraught to say, because some of these issues are, as you said, Black maternity is incredibly dangerous, and the reasons for that are incredibly difficult to fix and
Right.
not address in a way that the court can just kind of, I guess they can easily brush it off. Maybe that's the point. But I think missing the point is kind of how I want to wrap this up. And I really want to get into the debate, the Batson argument, because I think that really pulls it all together. But let's move to affirmative action, because this happened, what, 10 years ago now? And we're seeing some of the ramifications. And I think when the DEI challenges that are going to be coming down the pike really play into what the court decided 10 years ago. So can you tell us how, because I love what you do with this argument by saying, even though it seems to be supporting a people of color, Asians in this, are being legitimately discriminated against, is actually moving the goalposts for white supremacy. So you could talk about that, because I think it totally sums up what we're talking about here.
Yeah. No, so Students for Fair Admission versus Harvard, Students for Fair Admissions is an organization. And the organization, its membership is students of Asian descent. And this organization claimed that Harvard's admissions program, as well as UNC's admissions program, discriminated against Asian, students of students of Asian descent. And the truth of the matter is, yeah, so, the truth of the matter is that Harvard's admissions program did discriminate against students of Asian descent, but it wasn't the race conscious element of the admissions program that harmed students of Asian descent the most. In fact, it was a race neutral element of the admissions program called the personal rating. And that rating, students of Asian descent scored lower on that rating than white students. And there's a couple of reasons, these couple of theories as to why students of Asian descent scored lower in the personal rating than white students. And most of them have to do with implicit bias. Most of them, like this rating was a function of recommendations by teachers and college counselors and, and this alumni interviews. And the idea here is that students of Asian descent scored lower on the personal rating because these evaluators just didn't think as highly of students of Asian descent. There's this stereotype of Asian students as like being kind of book smart and nothing else, right? Like they're not charismatic, they're not really helpful. People don't really like spending time with them. They just study and it's like kind of like pathological. And that sort of sense was reflected in the personal rating. It's important for listeners to understand that Students for Fair Admission, the organization, knew that the personal rating harmed Asian students and benefited white students. The First Circuit described the litigation as hinging on discrimination against Asian students to the benefit of white students. Nevertheless, the organization didn't ask the court to strike down that personal rating. Instead, the organization asked the court to strike down the element of the admissions program that was race conscious, the element of the admissions program that benefited Black, Latina, and Native students. And so even today, Harvard still has, so it can't do the race conscious element of the program anymore, but it still can do that personal rating and Asian students are still being discriminated against, and white students are still benefiting from the discrimination against Asian students today. And so that leads me to conclude in the article that Students for Fair Admission actually isn't representing the interests of Asian students. Students for Fair Admission is representing the interests of white students who feel like their seats are being taken by Black, Latina, and Native students. So when we understand the litigation from that perspective, we understand that this isn't, this litigation is not, Black versus Asian or Black and Native and Latina versus Asian. Instead, it is what it has always been with affirmative action litigation, which is a white claimant saying that Black, Latina, and Native students are taking their seats. And the court has always been sympathetic to that argument. We can go all the way back. There's a case called Bakke in 1978, right, that started this whole like diversity rationale. In Bakke, the court is so solicitous of the feelings of white students who feel like they lost out on seats in the incoming class to like Black, Latina, and Native students. And this sense that, this sense of umbrage, this sense of unfairness, this sense of like disappointed expectations has been given the force of law. And so when the court says Harvard, UNC, all colleges and universities, you guys can't do these race conscious admissions programs, essentially the court is saying we're going to give white people's disappointed expectations the force of law, and we're going to disallow institutions from trying to increase the numbers of students from historically underrepresented groups in their incoming classes.
Yeah, and I mean, when you say that it's because of white feeling, I mean, it really is explicitly about how does this make you feel as a white person in the transcript of the arguments and the decisions, correct?
Absolutely. In Bakke particularly, Reva Siegel, she's at Yale. She has done some really incredible work on this, and she has articulated, she's described how like from 1978 until the very recent past, the court was very explicit about its concern with white people's feelings. In Bakke particularly, Justice Powell, who wrote the opinion or the relevant opinion in that case, he talks about, white people will feel that these programs are unfair. And because they will feel that these programs are unfair, it will create sort of dissension so it's not like a subtle or implied concern in these opinions, but it's very much articulated. And so it was only in sort of more recent years that the court kind of transmuted that explicit concern with white people's feelings into sort of this sort of universalizing language, this concern about racial division and race relations and things like that. But underlying that explicit articulation with just like race relations in the U.S. is this um, very, very deep concern for white people's feelings. And I say in the article, white people's feelings are kind of been determinative of the legal question. Like the court has allowed white people's feelings to answer the question about whether a law is unconstitutional or not. And then when you compare that to Black people's feelings, when you compare that to non-white people's feelings about the unfairness of the court has never thought that those things, Black people's feelings about, for example, stop and frisk or police violence, right? They've never felt that Black people's feelings on those issues answer the constitutional question. So we have this sort of deeply unequal treatment by the court. And one other thing that I'll mention, and I won't dive into the weeds on this, is that when you look to another sort of area of law, the disparate impact area, in which the question is whether a law that disparately impacts a racial group is permissible or not. It's only when you really look into those cases that it becomes kind of like it becomes plain as day that the court is sort of allowing white people's experiences of these laws designed to kind of produce some semblance of racial justice that white people's feelings of these laws are actually going to determine whether they're permissible or not.
And I think that that really brings home the standard, the difference between the two standards, where there basically has to be a Klan member punching you in the face for there to be black racism against a person of color, and it on the white side, it's, well, I don't feel like that's fair.
Yeah, absolutely. That is a great way to summarize the argument.
One of the things I've learned over the course of learning more about the Supreme Court is that it's always been terrible. Is it going to is it going to continue to be terrible? What can we expect? And what can we look for as an educated viewer or observer of the court? So as these cases come down, what should people be aware of? And what would you, if someone was going to take away like a couple of tools, what would you
Yeah.
offer?
Oh man, what a great question. I want to begin my answer by just affirming your statement that the Supreme Court has always been terrible, right? It's important for people to understand that this isn't like new. This didn't start with, Trump appointing Amy Barrett, Coney at the last minute. Like it didn't start with Kavanaugh. Like the bad precedent that I have been complaining about for my entire legal career. I can date that back to 1978, so, right? I can date it to the 70s. And the 70s is important to understand, like that was when the Warren Court ended. And the Warren Court, some of your listeners, might understand the Warren Court was this incredible court when it comes to sort of racial justice. The court was very sort of furthered the claims of the civil rights movement with regard to protecting Black people and other people of color from racially burdensome laws and processes. So for at least half a decade, the court has been terrible. So this is nothing new. What can we expect? We can expect more terrible decisions. um, I like to say, and I think that very few people, if they're being honest, would disagree with me, that the court is really just the judicial arm of the Republican Party right now, right? And that's a provocative thing to say because the court is supposed to be apolitical. Like we have political branches, we have the executive branch, we got the legislative branch, but the judiciary, though, that's supposed to be the apolitical branch. But the court is very much a political actor, perhaps slightly more so than in the past today. Um, and so what we can expect is that the court will hand down decisions that are just consistent with the Republican Party's platform. So if the Republican Party has launched a war against trans people, well, then we should expect court decisions that permit that war. If the Republican Party has decided that DEI efforts are, anti-democratic or bad policy, well, then we should expect the court to hand down decisions that hold that the DEI efforts are impermissible. I mean, we can see this. One thing in my scholarship that I look at is kind of just like inconsistency and parents' rights when it comes to critical race theory and DEI kind of has ruled the day because white parents particularly have said that critical race theory is bad. It is, making white kids feel bad about themselves. It's discrimination because white people feel harassed when they learn certain things about this nation's history. So parental rights have sort of ruled the day when it comes to thinking about, CRT and removing sort of progressive racial thought from curricula in schools, K through 12 schools. But when we talk about parents' rights and trans kids, where is it? Where are they? Right? Because parents are saying, hey, allow me the ability to care for my kid. My kid needs health care. Allow me the ability to access this health care so I can care for my kid. nobody cares about parents' rights anymore, right? So it's that inconsistency that that demonstrates the political nature of these positions. And so when the court, on one hand, upholds parents' rights, and then in another case strikes them down, we start saying, maybe you're just a political body after all, and there's no sort of principle, no apolitical, neutral principle that can explain those two decisions. So I would invite, the listeners and the watch in the and watchers of this particular program to just be attuned to how these decisions that are coming out just will, align miraculously with the Republican Party's platform. And that is just evidence that we're talking about a political body.
Yeah, I mean, just that decision they made about presidential immunity during the middle of a presidential trial was, yeah.
Isn't that odd? Isn't it weird? It's such an odd decision because, again, this is a court that appears to be very solicitous of history. It's supposed to care about history, right? And when you think about the history of this particular country, and when you think about our founders' concerns with not having a monarchy, about making a democracy in which there was no particular actor that was above the law, you just can't square Trump versus US with our framers, our founders' concerns with not having a monarchy, and ensuring that every official was subject to laws. You just can't square it.